thanks a lot for being here, Chris. I really appreciate you joining us today.
Thanks for the invitation to be here, Gene. Appreciate it.
Sure. I figure we have a lot that we can cover today, including the bills, legislation, a little bit of the politics of innovation and patent policy, which are not Republican or Democrat. It's just it's largely where you find yourself in the country and who your constituents are. So that's what I had in mind. So why don't I just kick it to you to begin with, and why don't you tell us a little bit to begin with? What are you working on this week? This week in the life of Chris Israel.
This week. Well, this week's been a little bit slower as Congress is out, obviously on August recess. So we're kind of catching each other at a time when we've come off quite a bit of activity. I do think there was quite a bit of activity up until this August recess, a number of hearings, a couple of bills that I think we were optimistic might have been marked up and moved out of the Senate Judiciary Committee, the Prevail Act dealing with PTAB reform, and PARA, the Section 101 bill. So, right now I think as we're a day out from Vice President Harris announcing her running mate, Governor Walz from Minnesota. We're coming up on the Democratic convention in a couple of weeks. We're on the heels of the Republican convention. So I think we're at a little bit of a period where, to the extent people are kind of dialed in looking at IP issues in the month of August, there's definitely interest in, what do people see in some of those cards as they, play themselves out over the course of the summer and into the fall. So, we're getting questions about speculation around where Vice President Harris kind of has been and might be on some key IP issues, looking back, and kind of pulling some things and some cues out of the Trump administration's 4 years and, some of the things they did on the IP front, and obviously had a, pretty muscular IP enforcement framework, particularly with, kind of overseas concerns in China. So, it's kind of some broad brushstrokes of, as we sit here in the middle of summer.
Yeah, people just trying to figure out what the lay of the land may look like. Is that kind of what's going on?
Yeah, I think so. Obviously there's, kind of ongoing things that are not susceptible to kind of the congressional timetable and flow, right? There's litigation, there's, regulatory decisions and things that the administration kind of has out there that are continuing to move forward, things like the terminal disclaimer, proposed rulemaking, the March-in framework that was proposed late last year that's kind of still out there. So I think, there's certainly anxiety around some things.
Have they made the March-in stuff final yet, or is that still in proposal form?
It's still in proposed guidance format, right? So
now, was that proposed guidance that they were going to start to follow right away, or pending making it final, or is that really we're proposing to do this and we haven't changed anything yet?
The latter is my understanding of kind of where things stand, which is late December NIST proposed potential guidelines, new guidelines, refreshed guidelines for federal agencies that handle large R&D portfolios and that would be subject to these types of petitions to kind of march in. And they kind of laid out what could be a new framework that would be much more considerate of price dynamics, right? And that's kind of where
that was really. You're a politician, aren't you? Yeah. I mean, because that was just
not quite.
That was. You couldn't offend anybody by saying that. I mean, a lot of people would just say they're just going after price controls. This is all about drugs.
It is. Yeah, I think that's right. So, yes. So this came out, so maybe we can kind of kind of go where you're going with this for a moment, right? And that was the immediate reaction, which was this applies, the auspices were drug pricing. I mean, you look at the White House press release and the one-pager and the statements that all came out. The press that was attached to it was this is going to be a powerful tool to address drug pricing. But the guidance is written and presumably intended to apply to any and all categories of federal technology transfer or patents that have been licensed from the federal government. So very quickly, I think you saw manufacturing organizations, the venture capital community, certainly the university community and the tech transfer offices at many, dozens of large research universities were saying, wait a minute, this applies to everything. Pricing was never intended. There was very overt and specific language from the authors of this bill saying, we thought about price and we didn't include it for very specific reasons, right? And so all those comments kind of flooded in to the Department of Commerce, and a lot of additional activity. There was congressional letters, there was opinion pieces, and lots of material kind of populating the discussion here. And I think overwhelmingly opposed is a fair way to frame that, right?
I mean, I would. I didn't see anything that was in favor of it. I'm sure there were, but I didn't see any myself.
I think there were. You'd have to go through everything that came into NIST, but I'm sure there was some, patient advocacy groups and some people, kind of advocates for, in the pharmaceutical sector who said, hey, this is a great idea, and I presume had their reasons for it. But I think well, I mean, it would be a great idea if it would work, but working requires two things in this space. One is that you still get the same level of innovation, because since Bayh-Dole came into being, it's runaway amounts of innovation coming out of universities. And then the second thing is it would have to actually affect drug prices. And I don't think that would do that either. No. And it would, I think it would work once, right? Maybe it would work once. I mean, you come in, you do it, and it has, maybe it has an effect in one instance, but everyone in the innovation ecosystem is going to read that tea leaf and say, well, why exactly would I put several $100 million into this? Why would I license anything from that has any legacy of federal research attached to it? It kind of puts a scarlet letter on that whole body of research that the federal government puts a lot of money and resources into. And like you said, since 1980, Bayh-Dole's been a runaway success.
Right.
I mean,
it's funny how you say that. It would work once. And that's the way, and I laugh because I think that, when people are talking about doing things that take away rights, IP rights in particular, very easy to take away somebody else's IP rights because it's just what you thought of in your head. So I'm just only taking away your creativity. But it works once, right? Because you take it and you get it, and then once downstream, it has an impact. It's a chilling effect, and there won't be as much to take the next time, if anything to take, because I don't know how anybody could do a deal with the federal government if this goes into being.
You wouldn't, I don't think, as the entrepreneur, and certainly your investors wouldn't put the money behind you to, follow that however many years long progression it's going to take to actually get something commercialized, which, almost by definition, and, part of the framework too, or the theory is that, well, these petitions would come to, federal agencies asking them to march in. The people who would presumably, or the entities that would be filing these petitions, would be much larger, more efficient incumbent competitors who would come and say, well, hey, I could do that much more cheaply. There's examples of navigation tools and other kind of manufacturing products were kind of given as examples. And you kind of step back and you say, well, almost by definition, any large entrenched incumbent global manufacturer could come in, look at a startup who's got a new disruptive product and say, well, I could do that more cheaply, right? Or I could make that much more cheaply than it's going to take you to make it. And that startup may have spent $1 billion making that first product. Right. And so you kind of like, well, yeah, of course. But if that won't work. That's not sustainable.
It's not sustainable.
Every time.
And the second comer always has the opportunity across the board to charge less money because they didn't have to innovate it. They didn't have to spend the money to create it. And when you're talking with drugs, and not only drugs, but a lot of things, including children's inventions that relate to children, because there's a whole regulatory scheme to make sure that they're safe. Yeah. So if there's a regulatory scheme there, not only is it that somebody had to invest in the R&D to make it, but somebody had to invest to make sure that this passed regulatory muster, which in some areas is quite expensive and time-consuming in and of itself, like at the FDA.
Yeah, 100%. Yeah, I mean, there's all this downstream cost, right?
Do you think that the folks on the Hill, or let's just say in Washington loosely, whether it be agencies or on the Hill staffers or members of Congress, really get that the impact of their decisions And what I think about when I'm asking this question is it has shocked me to talk to my friends who do work at the ITC that they say they still have questions from clients asking about when President Obama stepped in on behalf of Apple.
Yeah.
And that happened exactly one time in 40 or 45 years, and it hasn't happened since.
Right.
And yet, because that is a potential, people are worried about it. I mean, do folks understand that it only takes once to get the whole industry skittish?
I mean, yeah, I think people increasingly do. I mean, I definitely think there's a much better sense of the tremendous impact on the market and on innovation the decisions about patents have. I mean, I do think, if you back us up to maybe AIA and pre-AIA, there maybe wasn't as much of a, maybe the kind of the patent community wasn't stressing and wasn't as articulate about indicating the implication of these, which seem like, small modifications to the patent system, right? That have these really profound downstream impacts. So I would say, yeah, that's improving. I don't know that universally every member of Congress would tell you that, doing something to the patent system really is, a hugely impactful thing. I do think it's still a little bit of a domain of a few experts, and they'll tell you,
Which that shocks me all at the same time as it doesn't shock me. I mean, the reason I say it shocks me is for the same reason I find it difficult to understand how CFOs and CEOs and to some extent general counsel don't really, at some of the largest companies, don't really understand IP. When you look at the valuation of their companies, for a lot of them, it's all IP. Yeah. It's trademarks for some of them. For a lot of them, it's patented innovation. It's trade secrets for a lot of them. But the whole IP umbrella defines 80-90% of the value proposition for a lot of these companies. And so it's always shocked me that you're not putting somebody in one of these top 2 or 3 positions that really is IP knowledgeable, whether it be a lawyer. It doesn't have to be a lawyer. It could be somebody from business, who, like Tom Tillis, worked for IBM for a long time and then grew up with understanding the innovation ecosystem, right? And then the same thing happened when I think about Congress, is so much of our GDP is tied to innovation, creativity, copyrights as well, that I wish that there were more than just a couple people who we could name. Right. We wouldn't need all 10 fingers to name the people in Congress who really, I think, treat this as, quote unquote, one of their issues. Yeah. What do we do? How do we break through? I mean, I know this is the battle you fight all the time.
Yeah, and we're maybe too close to it to kind of have that big picture answer you're looking for. And I know I know a lot of additional people that we work with are thinking about this all the time. Former PTO officials and members of the judiciary who are really trying to stress this. I mean, and there is this disconnect because you do hear so frequently members of Congress, policymakers, talk about IP and how important it is. And, you hear it in the context of the China discussion. And I think every member of Congress would reflexively say, if you start talking to them about China, would say, yeah, we've got a big problem with IP theft. I mean, it's just embedded kind of in the psyche at this point, and it's internalized, and everyone takes that as a given, right? Of course, we're in this kind of battle for ideas and enforcement and, the supremacy of the ability to protect your IP with the Chinese. And we need to do something about it, right? I mean, there's always like, yes, get more aggressive, do this, do that. And the federal government stepped up, and I do think over the last 10, 15 years, we've generally done more. But then, it's making that the connection with that global worldview that IP is so important to the U.S. and China's coming after it and other countries are coming after it, to, connect that to either why you do or don't take a position on a particular bill, right? I mean, that's a difficult it's a difficult connection to make, to say, look, you as a member of Congress, I'm sure believe we need to do more to strengthen our IP system vis-a-vis China. I would make the case a couple of immediate things we can do is let's fix some of the flaws in our own system, right? Let's stop doing harm to the U.S. patent system in this instance, right? Let's stop attacking patents as a problem and saying they're to blame for high prices in fill in the blank industry. Right. So let's stop harming the patent system and start healing it. Let's address this uncertainty around 101. Let's fix some of these known flaws and inconsistencies in PTAB. So that's the, like you say, that's the tactical battle. I mean, on the strategic level, I think just most public policy makers, except for a few, would stipulate, it's a good thing for the United States to produce intellectual property and protect it.
Right.
But then what do you do about it? Right?
What do you do about it? And that becomes the problem where I started. It's not a political issue in the D versus R kind of way.
Yeah.
It's largely because like, for example, in the Senate you have Coons on this side and you have Tillis, and they're on opposite sides of the aisle. And you do, maybe when you get to the agencies, the R and the D matter a bit more. But on the Hill, it seems what far more matters is who are the companies in your district, in your state, and what's important to them. Because I just fundamentally think we don't have a working definition of what it means to innovate. Because a lot of people, I always treat an innovation has to be new. And the fact that you have never done it doesn't mean that it's innovative.
Yeah.
It just means you have never done it. And that word gets bannered about, because I don't know anybody that's against innovation.
Yeah.
I don't know anybody that's against protecting innovation even. The question then becomes is well, what's innovation to one is not always what's considered innovation to another.
Right. Yeah, and I think, there's a huge fight over what happens with that innovation. And I think there's a view that, it's great. We need more innovation. We want more innovation. We need, treatments. We need better technology for quality of life and productivity and enhancing our communication capabilities. We want all those things, but, we want them instantly created, produced, and then almost instantly distributed universally across the population, right? And I think that's those two things, just from a systemic standpoint, aren't always possible, right? Or usually aren't possible. And I do worry a little bit, going back to your earlier point, Gene. I do worry a little bit that it is becoming a bit more partisan.
I saw you. I noticed you kind of, I wouldn't say roll your eyes, but you look a little concerned when I said that. What's going on there? What are you thinking?
Well, look, I think that patents in particular, I think, have become conflated with debates about inflation and the cost of products, right? And there is this, and I do think that becomes, and I think, kind of, I won't say from a party standpoint, but maybe from an economic philosophy standpoint, I feel like you do see more, progressive economists and others looking at the patent system and saying it's something that exists to create a good. We get it, but we also have to deal with the problem or the situation where that exclusivity allows or creates high prices. And I think, you see, so I do think you see some tension, and I do worry that that is starting to set in where, particularly kind of from that vantage point, there's less data and good arguments around what's the good for society that patents are creating. The fact that we do have all this innovation and all this investment going into it. What's the good and the quality of the patent system from the perspective of the consumer and the citizen, right? What's that? It's kind of the societal good that patents create. We've heard a lot about cost dynamics and economics around patented technologies, but I think we need to do a better job of explaining that there's a lot of societal good that happens because the United States creates all these breakthrough technologies, and they're able to be developed, invented, and commercialized here. So, where I think, on the maybe more on the conservative economic thought, I do think this sense of intellectual property as a patent, kind of a classic patent or a classic property right has sunk in and is pretty deeply rooted, where I think you'll get more, kind of conservatives saying, yeah, it's a property right. It needs to be protected, right?
Yeah, it's interesting you're saying that, because I've always wondered why it was not more of a D versus R kind of political issue, because certainly over the last decade, if not longer, what I think you have seen is the left become more closely aligned with Silicon Valley, the internet companies, the internet giants, and what's good innovation policy for them doesn't seem, and I don't think that this should be controversial. It's just what they see as good innovation policy is not seen as good innovation policy by most of the rest of the innovation sector, whether it's life sciences, universities, or startups or individuals.
Yeah.
They tend to be on one side. And so the left has become more aligned just philosophically with a group of people that have a certain view of what it means to innovate. And I get it. They're the targets of a lot of these lawsuits. And I do feel like there's abuses on both sides. I'd never liked the patent troll narrative, because it became so easy to say that whoever's suing me is a patent troll.
Right.
My patents aren't the problem, because we only get good patents. It's everybody else's patents that are a problem. Right. But that's not to say that trolls or bad actors don't exist on the owner side. I think that they do. I just worry that we've spent so much time over the last 10 to 15 years trying to address the outliers that we've taken the system out and capped it at the knees.
Yeah, I think that's definitely true. I definitely think that a lot of the policies that were put in place 10, 15 years ago were designed explicitly to address those edge cases. Those were the case. That's what you heard. That was what was driving the debate. There's these kind of, edge cases in which you do see these, abusive characteristics, and, companies were able to come forward and say, look, this is what happened to me, fix the entire system.
Right.
Because there was a couple instances where, where we face this type of situation.
It's like they're not engineers, because an engineer would not throw away the whole system to fix a
so
problem.
We did.
So we did.
We did. We said, okay, well, we're going to create this whole new structure in which, all these second, third, fourth, 6-time reviews are capable, and anyone can bring them, PTAB, obviously, right? And we're going to kind of put no constraints on the ability, and we're going to incentivize this agency and almost, put in statute the philosophy that the patents that you granted on the front end probably aren't that great. So, you all need to kind of come in with this bias towards taking a critical look. And,
Right.
I've heard the PTO director say, take them off the market, right? I don't know that, that a thesis for a federal government agency should ever be to take something off the market.
Right, particularly something that they created.
A property right that you yourself granted in the first instance after, a couple of years of review, right? So,
and that same kind of mentality is going on now, I think, with, like, for example, the terminal disclaimers. It's like, well, we don't want so many of these patents. Well, it's your examiners that are issuing them.
Yeah.
And oftentimes it's your examiners that are being told and allowed and encouraged, and there's nothing wrong with this, but that's just what happens, to issue restrictions and to carve these applications up into more bite-sized pieces.
Yeah.
Perfectly fine. I have no problem with that. It's more expensive for the person seeking rights, but okay, that's their game. I shouldn't call it a game, but that's the rule. Those are the rules, and we can live by them. But when you wind up 5-10 years later in a continuation or in a adjacent patent that now they're going to make you file a terminal disclaimer on, saying, oh, we'll give you this, but we really shouldn't be doing this. And, what you're saying is that right that I'm now going to give you 5-10 years after the fact is something that you should have gotten 5 or 10 years earlier.
Yeah.
And so who's to blame for this? And what I see in the industry right now, and the rules and the laws are always to blame the innovator. It's like, innovator, you did something wrong. It's like, no, the examiner wouldn't give me these claims. Now they've given them to me, recognizing that my original disclosure supports them. You should have got them 10 years ago.
Yeah.
Do people see that? And they also, I mean, I see the damned if you do, damned if you don't. I look at a lot of portfolios, particularly my expertise is in software. And you can see, like, with every change in the law, every new case, some of these companies that are filing lots of software applications, they adjust the way they write the applications.
Sure. Right.
And the end outcome always seems to be, well, not good enough. And I just get frustrated. I mean, I'm sure you get frustrated too. I mean, or maybe I shouldn't put words in your mouth. How do you describe what's going on with this? Because I can tell you a lot of inventors and small companies feel like the rug gets pulled out from under them. I was following the rules at that time, and now the rules have changed.
Yeah, no, 100%. We hear that a lot. You know, we work with a lot of venture funders, startups, you know, innovators, entrepreneurs who, I don't know. I mean, you know, historically, I don't know, but this feels like the last decade or 15 years has been as, you know, kind of fluid and inconsistent in terms of patent law as any period we've maybe ever had, right? I mean, we've taken away injunctions, we've changed rules about eligibility, you know, we've created all these new, you know, it's gone back and forth kind of between, you know, different administrations and different leadership structures. So, you know, at a time when I think we should be making things, you know, more predictable and consistent, particularly for the smaller companies who are really at the cutting edge of a lot of these industries and innovation, right? I mean, we seem to be kind of consistently making it more difficult for them and less predictable for them, you know, enforcing, as you say, forcing these different changes and variations in the way that they, you know, file for and assert their patent portfolio. And I think you're right. And oh, by the way, you know, there tends to be this bias towards or this assumption that they're doing something wrong, you know, that they're trying to game the system or they're trying to abuse the system or, well, you know, you're getting too many patents on this incremental innovation, right? I mean, it's like you've got a patent on this, but then, you know, so there's always, it feels like that's kind of where a lot of startups and entrepreneurs are finding themselves, which is, you know, you're changing the rules all the time. We're trying to adapt and keep up with it and run our company and do, you know, innovative things. And oftentimes, you know, we're the ones who are then looked at and said, well, you know, you guys are, you're bad actors or you're trying to abuse the system here.
Playing by the rules. And the rules get changed. I mean, that's just what happens, and it's frustrating for a lot of different. One thought that comes to mind is I do think there are way too many patents that are issued, but they're not the ones that the patent office or the courts or Congress are worried about. Yeah. I mean, if you go and you just over the summer for a project that I'm working on, I just been perusing the Office Gazette every Tuesday after patents are issued. And there's maybe not quite the craziness that you saw pre-KSR, but there are some, to call some of the patents that get issued thin is mind-boggling. I mean, it's just inaccurate. I mean, there are things like a couple of weeks ago I saw another plastic Adirondack chair patented. Do we really need another plastic Adirondack chair patented? Yeah. No, but there's that kind of craziness. And then you go and you look at some stuff that can't get issued, and it's like, oh, come on. You know, there are at least two different patent offices we have. One for the stuff that they think that's going to matter, where it's very hard to get good, solid rights and very, very difficult, if not impossible, to keep them. And then there's the, oh, well, you're just a Joe average inventor. You're going to maybe selling this on QVC. Yeah. Well, you know, so we can give you a patent. But I also think that then creates a situation where you see the people like, you know, like Josh Malone or like Molly with her jump rope. They got patents. They were told, they followed the rules. Yeah. The examiner said they were unique. Right. And then they started making money on them. And then people come and start to challenge. And it's like, I think we got to pick a lane. You know, either we're going to give patents away or we're not going to give patents away. And it seems like we have one foot in both worlds.
Yeah. Yeah. I mean, I can understand, you know, certainly you can understand that frustration, right? And I mean, if you... Right, and you played by the rules. You know, you got the patent. I mean, you played by the rules as they were given to you as the inventor or the small company or the startup, and you went out and you commercialized your product and you put a lot of big bets on that. So yeah, I don't, you know.
And in Molly's case, she had 40 employees.
Yeah.
You know, and the party that was coming and challenging her was from China, right?
Yeah. Yeah.
I mean, when you say these things out loud, it kind of makes you scratch your head and wonder, Was there anybody paying attention and watching this and seeing this unfold to this, American success story?
Yeah. And then how do you, you're right. I mean, how do you, anticipate that? And if you don't anticipate it, how do you then build into the system the tolerance and the capability to think through those factors as they're making these, downstream decisions, right? Where I think you're right. The theory that, we're going to have this review process that's going to weed out the bad patents or the patents that shouldn't have been issued, I think made sense on paper, and it kind of made sense as I think the politicians were convincing themselves that that's what they were doing. But they, now decade on, whatever, they moved on, right? A lot of those people have kind of moved on. They're attacking other problems or addressing other issues. So I don't think there's another thing that's not usually true on Capitol Hill is that you have, members or leadership that's, kind of longitudinally wedded to the success of a program or a policy that, stays with it for a decade to make sure that it's doing exactly what they said it was going to do or they thought it was going to do when they put it in place, right? I mean, it's typical. You pass a bill, you have a signing ceremony, it sounds great, and everyone kind of moves on. And then, all these things start to manifest themselves downstream or in the out years, right? And the system's generally not built to have that type of, kind of curative process.
Or even,
even
flexibility. Common sense would go a long way, I think, with some of this stuff. And I was just totally unrelated to this, but like one of the dumber things I think I've ever seen. About 15 years ago, the Patent Office started accepting credit cards. Well, when you file something, it's all going to become a public record. So they had passed in the rule, if you use our form, we'll remove that form before we publish it. So, the Patent Office forms, they've gotten better, but back then they were almost impossible to use. Yeah. You couldn't, some of them weren't fillable, some of them weren't savable, some of them you could save, but they would save blank, they wouldn't save filled. So firms created their own forms, which the rules let you do. But the rule specifically said we will redact our credit card form, not the credit card form that we will let you use that you created. So they just started publishing all this credit card information. And it's like, that's government in a nutshell. Sometimes it just gets too strict, too stringent, no flexibility, and it can cause real damage. And I think that what we've seen over the last 15 years is the people who are most in the position to provide flexibility for the system, I think, are the district court judges. And they have been so thoroughly just overruled, ignored. What you're doing is wrong. It's never right, and it's I get the frustration. I mean, why would you want to do a patent case if you're a district court judge? It's a coin flip whether you're going to get overruled or not. You're
going to get reversed, right? Yeah.
So I don't think that system. And the thing too is like with the injunctions. I mean, why can't district court judges figure that out on their own? I mean, and we just had the restore bill finally. I guess it was put into play. It was introduced
in the Senate a couple weeks ago. Yeah. Right before they went out.
Do we have anybody on the House side that's looking at that? Or
No, there's a couple members who are interested in introducing that, and actually did introduce it alongside Madeline Dean, Congressman Moran from Texas. So there's some strong bipartisan support in both chambers.
So we've talked a lot about the industry, about PARA and Prevail, which are the PTAB bill and the patent eligibility bill. But the new one, and probably maybe the most important one, is Restore. Can you tell us what's in there?
Yeah, no. So Restore is a bill that was introduced Senate and House. I think it's a page and a half, maybe, right? A very straightforward bill that would restore the presumption of injunctive relief in cases where a court finds infringement. So my understanding is that pretty much takes us back to the days pre the eBay decision in 2005, 2006, where that was generally the standard for a couple hundred years, right? The injunctions were generally pretty easy to get or a little more straightforward to pursue when you've got a finding of infringement in a federal district court. and that's become largely, impossible or extremely rare in the United States over the last 15 years or so. So I think, I made the observation at the time, and others have too, that, in a world in which, and we were just talking about the complexity and the kind of ever-changing nature of patent law and patent legislation, this is a pretty straightforward bill. I mean, this is probably about as straightforward as you'll see from
Ever.
a piece of patent legislation, right? Just instructing the courts to kind of toggle back to this place where you generally presume that, you have a rebuttable presumption, of course, that you can pursue this an injunction if someone's found to be infringing your patent, which is, I think, extremely close to the constitutional intent of why property rights were enshrined in the first place. It's the right to exclude. It's the right for me to say, no, Gene, I invented that. That's my product. I'm selling it right now.
Yeah.
You have been found to infringe it. You cannot enter the market or participate in the market directly competing with me. I mean, that seems like a fairly straightforward.
Well, the thing that's always amazed me about all of this is you, at least in theory, as a patent owner, have an exclusive right before the decision, before the district court decision. Then once the district court finds that there is an infringer and that none of their defenses or invalidity arguments prevailed, so your patent is going to stand and they've been infringing it. Well, now all of a sudden, you don't have an exclusive right. It was exclusive right up until that decision, at least based on the paper you were given, the grant from the government.
Yeah.
And the only thing that the injunction lets you do is if, Chris, you ignoring the injunction I got for my patent, I get to go back to the district court, go to the front of the line and say, Your Honor, Chris is ignoring your order. Without having to file a whole new patent litigation case, which will take 5 to 10 years to work their way through.
Yeah.
And to me, it doesn't strike me as out of the ordinary given the whole purpose of the patent system. But for some, it just is a...
This is a third rail, right? I mean, this is going to be, I think in terms of simplicity, this might be the most straightforward piece of patent legislation any of us will be talking about, but it's probably the most controversial piece as well, right? I mean, this is kind of existential to the business model of a lot of large technology integrators, a lot of big tech companies where they have institutionalized that dynamic you just described, where it's like, look, I'm just going to put the product out. If I infringe, we'll figure that out later. They're going to have to prove it. I'm innocent until proven guilty, so I'm just going to full speed ahead. I'm going to put this thing out there, monetize it, build a model, build an economic presence for it, probably make, tens of millions, billions of dollars, and they can't stop me. Even if I'm found to have infringed it, they can't force me to take it off the market because you're not going to be able to get an injunction, generally speaking, right? So if you restore that ability and that leverage, put it in the hands of the patent owner to say, it's a plausible outcome, or that you may be forced to withdraw that product from the marketplace in the United States. That I think one immediate thing that does is it rebalances the leverage proposition, because I don't know a lot of patent owners and the types that we're talking about, the people that are really trying to develop a market and commercialize it, getting it out there. They want to commercialize their product. They want to either sell it themselves or license it to someone who is better at that. And that's not, that's the natural way our economy has evolved. It's so big, it's so sophisticated. You're going to have companies that are very good at doing both those things, in some cases, great. And you're going to have some companies that are good at doing one of those things in some instances too, right? And I think we have so skewed the balance towards the implementers, towards the companies that are good at rushing sophisticated products onto the marketplace and kind of figuring out later the IP implications of those market movements. I think we need to restore some balance and say either, look, you need to do that at the front end, or when you're found to have infringed someone's intellectual property, you need to license it. Right? To me is like, that simple answer is one that I just think it's so obvious, but never really floats to the top, and you see it with the ITC debate as well. Like, oh, it's these exclusion orders, we should limit the ability of who can get them and make them harder to get because there's such a big remedy and they're so dramatic, right? Well, yeah, but I think, and it's not like there's not off ramps, right? There's not like there's not alternatives. It's like you could license it. And we wouldn't even be in this mess, or you could invent around it, and we wouldn't be in this mess, right? I mean, so you
could have invented it yourself. I mean, because a lot of these companies don't have the robust patenting processes that they would have if that law were to change.
Yeah, and that to me is like one of the more frustrating elements of this debate. When you go to the Hill, you talk to people, and they say, well, this is. We need to maybe do something about Section 337, or we should make it really hard to get injunctions, or PTAB should be used. I've heard this too. Well, everyone should be able to use PTAB and challenge it because it's a way to it's a way for companies to kind of pressure test the market and clear out patents that that may get in the way. I'm like, well. Yeah, it's good at that, but that was not the design.
No.
It was never designed to be this market clearing mechanism. Everyone would love to have that, right? I mean, I'd love to have the ability to, clear away lots of obstacles to the things that you might want to pursue, but that's not the government's job, is to help you get your competitors, basically, gut your competitors by taking out their patents. That's not what that was designed to do. And, you could, and some people say, well, it's that creates more competition. I would argue, no, it creates way less competition.
Way less.
All that does is isolate into the hands of a couple of entrenched players the ability to challenge and clear everyone, any disruptive competitors, generally always smaller, out of the way. And they still have those two options. You could invent around what these guys are doing, or you could license what these guys are doing. Right, so you still have these kind of options on the table for you, and it creates more competition. If you're facing robust new entrants that have sustainable intellectual property positions pretty consistently, that's very pro-competitive.
Absolutely.
To me, that's a tool that should be in the toolkit of our, those who are concerned about market concentration and monopoly power. I think should look at creating a more robust patent system that's enforceable for new entrants, and making that's something that should be in their toolkit.
Well, could you imagine the companies that have this policy now, and because it benefits them because they're large and they're the incumbents, they were all tiny.
Yeah.
Many of them, maybe not many of them, but at least some of the biggest ones started in a dorm room. Yeah. Or in somebody's, in your father's garage, at least one of the big companies, right? What chance would they have had to become what they are today if the current incumbents back then could have just trampled all over them?
Yeah, we'd have the same technology companies that were dominant in post World War II, right? I mean,
right. And that's not something you see in America. I mean, with the exception of a few. I mean, IBM has had great highs. And they've had great lows, and then they've been able to rebound and come back, and they always seem to, just before they seem to hit the bottom, reinvent themselves. They're very, very good, but they're the exception. I mean, do you remember when the term Wang was synonymous with computer?
Right.
And it was a gigantic building, the Wang building, and nowadays it's like, kids today wouldn't know that at all unless they took a computer history course.
Right.
And Tandy for a while, Radio Shack, they don't even exist anymore, for God's sake. I mean, companies that are tech companies burn white hot.
Yeah.
And we don't see that anymore.
And I think it's particularly systemic in that industry, right? I mean, there are differences. There are industry differences, I think, that also make these conversations about, what you were talking about earlier, is kind of having these cross-cutting common denominator solutions that make the patent system strong and fair and robust for everyone, right? I mean, there are just great variation in the way these companies and these industries operate. And I think it makes it really hard for policymakers for sure, because things can be simultaneously true. These fast-moving technology companies can come in and say, look, here, we're trying to do this. Were it not for these problems in the patent system, we could be doing so much more and so much better. And then someone else will come in and say, look, you're asking me and my investors to put a decade of our lives and $200 million worth of someone else's money into this singular thing we're going to try to make work. Maybe it will, maybe it won't. But if it works, at the end of this, we're going to have a handful of patents, and that's going to be the fruit of all this effort, right? And then we're going to have to go. And so I think they're caught sometimes in between, trying to figure out, like, all right, how does the patent system contemplate these dramatically different ways in which a lot of different industries and companies operate? Because we're America, right? We want it all. We want all these things to work. We want the best technology sector. We want the best AI, cybersecurity, semiconductor, life sciences. We want to be number one in all these things, right? And we're asking our patent system to enable us to be number one in all these things. And I think we see that's where the conversation we're having. You see these tensions and these pressure points where it's pretty hard for one legal regime to allow that type of dominance in everything.
Yeah. Well, and that's why I think we'd be better off giving the district court judges more authority. Because one of the things you always hear is that it's always a life sciences example, and it's always people are going to die if you issue this injunction because they're going to order all the hospitals not to give the patients tomorrow that drug.
Yeah.
Okay, there's not a district court, there's not a judge in the world that would do that. Sure. And I heard somebody, I think it was at one of our programs, talk about the way that judges overseas would handle that, and in some cases have handled that. It's like, okay, well, if you are a competitor and you could be providing that drug and they're infringing your patent, well, how long is it going to take you to replace their drugs that are infringing in all the hospitals with your drug? Mm-hmm. And if the answer is 6 months, okay, well, then the injunction can't start for 6 months, right? Yeah. I mean, there's all kinds of this stuff that we would ordinarily leave to the district court judges, who by and large are extremely sophisticated. Yeah. Some of the best and brightest people are on the district court, in my opinion, district court bench. Let them figure out the way the balance is, but with the presumption being that, no, there's going to be an injunction. It doesn't have to be tomorrow. Yeah. And we've put into these choices where that, if the injunction doesn't start tomorrow and kill people the day after. Yeah. No. Let's do this like adults, and we've lost that ability, it seems.
Yeah, I think that's right. I mean, and I think that's the way these things get debated on Capitol Hill. Is you see kind of the arguments are made at the extremes. Like this dramatic thing is going to happen if you don't do this, or this dramatic thing is going to happen if you do this. So so that for those who would prefer nothing to happen. I mean, that's the easiest default for a lot of members to go to, is like, well, I mean, okay, I get your argument that we should make some fixes, but I also don't want this awful thing to happen if we do, so let's just kind of check out and do nothing. I mean, I think you're right. I guess, in a perfect world, kind of this discretionary capability that's put in the hands of, the people who have, kind of have line of sight on these tough decisions that need to get made, is a great thing. But I also think, there was a lot of discretion that was built into the AIA. I mean, I remember having conversations with Hill staffers who were working on that language at the time, talking about IPRs and PTAB, and, well, wait a minute. I mean, what if you get this scenario where you have these kind of multiple challenges, or people kind of come in who aren't related? There was, some people who were raising these early end concerns or hypotheticals and being told, well, look, the director's got all the discretion they need. They can stop that. The director has unilateral discretion for any reason, to make these decisions about an institution and how these cases may proceed. So, I do think within the context of the AIA, your theory was contemplated and kind of embedded in that legislation. And I think, we could look at situations where that discretion has been used all over the map. And we could find a lot of
there
right?
are. I mean, it could go
or not used at all. Where
but the one thing that in what I'm suggesting, I think is a little different, and it's simply because we vest, for better or for worse, just all kinds of authority in frontline decision making. I mean, these people are called judges for a reason. You get A or B, and then if it winds up not working out, then you could have the federal circuit, functioning federal circuit actually fix that. But and one of the problems I think with the issue you just raised with the director is the discretion has not been used.
Yeah.
And that's been frustrating. Mm-hmm. But there's always something that's out there. I mean, I saw Judge Michel, though, going back to the Restore Act specifically, say, I think he told Eileen this, that he doesn't think it'll pass this year and maybe not even next year, but he does think it's going to pass. What do you think? Do you agree with that, or are you more cautious? Or
no? You have to be optimistic. I mean, right. I do think that this one's very straightforward to discuss. I think there's a lot of specific instances you can point to. I think the argument that other countries generally, like Germany, there is this, element of enforcement that's present in a lot of our competitors, and we're probably falling behind because of it. So, yeah, I think Judge Michel's timeline is probably pretty realistic. I also wonder too, it'll be interesting to see, do efforts like this have an influence on the judiciary itself, even if these bills, aren't, signed into law right away. I mean, if there's hearings and if there's focus on this, and you do get, a body of members of Congress who kind of, indicate this is their intent. I mean, does that? You'd know better than I. Does that influence judges? I mean, we kind of had that argument too with Prevail that, hey, well, maybe if some of the most relevant members of Congress with jurisdiction over this agency come out and say, we think this should be more what PTAB looks like, maybe it'll influence some of the actions and judgments coming out of that agency. I think that's a lot to ask for, I know, but
I don't know that it's going to affect the PTAB at all.
Yeah.
But Judge Michel will tell you, and I think he's historically correct, that it will affect judges in the federal judiciary. Because it has in the past. When you saw, the reason we were able to get the AIA was because some of the most controversial aspects of the bill back in 2006, 7, 8 were getting peeled away by the courts.
Yeah, they're
getting decided, particularly dealing with damages and that sort of thing,
and things like that. Yeah.
And I think it's accurate to notice that. When the Federal Circuit was first being formed in the late 70s and early 80s and gaining steam, that's when the Supreme Court had the Chakrabarty case and the Diamond versus Deere case, and very pro innovation, pro patent, pro eligibility. So I do think when things get serious, now I don't know that it's been serious enough yet.
Yeah.
Now you get these bills marked up, then maybe.
No, there's you got to go a ways, right?
We got to go a little bit further, but I do think that there's a light at the end of the tunnel. I don't think it's a train. I don't think we can get there fast enough, in my own personal view.
Yeah, that's the problem.
The last thing I just wanted to ask you, and I don't know, and this may be an unfair question to you, and if it is, we can wrap up and talk about something else. But I know you were very involved in the oil state debates and the questions about the PTAB and is this constitutional, and I know a lot of you did some work for folks on that issue, and as that was working through. I was just looking at the Supreme Court's decision in the SEC case this summer, where they said the agency can't issue a penalty because it violates the right to a jury trial. And I read that decision, and then I went back and I reread oil states. And I thought to myself, how could the same court issue these two decisions?
Yeah.
It's almost like they're written by it's like crossfire, like one person on the right, another person on the left. I mean, totally. Right. This can't possibly be the same court. And it was the same court within a span of less than 6 years.
Yeah.
Do you think that decision, or have you had any talks, or have you heard any rumblings about whether people might try and use that decision as an opportunity to relitigate some of the oil states' questions about PTAB. And the reason I raise it is because it seems that and maybe this is where maybe you could comment on. The Supreme Court seems to, over the last year or so, maybe a little bit longer, become a little bit more active with respect to administrative agencies. And
Chevron, right? I mean,
right. Chevron. I mean, there's a number of them. So I wonder whether is that a trend that's going to continue? Is it one-off? Does it give people some additional way to go back and make arguments about the PTAB? And I don't know that and the reason it's so interesting to me is because I feel like we're at an inflection point,
right,
where I think the courts and some members of Congress realize that they have ceded a lot of authority to a bunch of folks who are appointed by the executive and not elected.
I think that's true. I mean, you definitely, you obviously see that in para, the effort to remedy and fix Section 101 jurisprudence under the premise that the court got it wrong generally. I just don't know, Gene. I mean, I have not studied those cases well enough, and I'm probably a little over my skis to.
Well, no. I mean, that's good information because that means that nobody has asked you these questions yet, right?
We haven't. No, I mean, we might not be the ones that get asked those questions, because what's the right case to bring? What's the right challenge? I know there's a whole strategy.
Well, maybe after this conversation, you will be the right, because I haven't seen anybody really talk yet about this having any impact on the patent office or the thing. But I just because the decision, as I understand it from the SEC cases, is that you can't have an agency issue a fine, and it's a penalty, right? Well, I think to myself, well, what worse penalty could somebody in our space have thrust upon them than you've invested all this time, money, and energy in this patent, and now it's taken away.
Is it a takings, right? I mean, I get you kind of into takings theory too, I guess.
So it is interesting to me that nobody's brought that up to you.
I haven't been part of any conversation.
Yeah, so that means that I'm either way off in left field thinking about this, or I'm ahead of the curve.
You're way ahead of your time.
I'm ahead of the curve.
You're way ahead of the curve, probably, as usual, Gene.
I don't know about that, but thank you. Yeah. So, well, I really appreciate this. This was fascinating. Is there anything in closing or wrap up that you want to make sure people flag as important or know about moving forward?
No, I mean, I think we hit so much today. I mean, there's so many moving parts, and it's interesting, fun, and kind of challenging to talk about them all at once, because you just realize how many kind of things you're working on simultaneously. And I do think I think we're going to see things like AI and new technologies and new open up a lot of new IP issues as well. We're spending a lot of time trying to think about some of those, and they probably exist a little bit more maybe on the copyright space than in the patent space. But never a dull moment.
Yeah, I'll just say the thing that just caught me, just like I think many of the people talking about this issue have jumped the shark, is so many people spend so much time talking about whether AI can be an inventor.
Yeah.
And there's a whole lot of real human inventors and inventive teams that are inventing in the AI space that can't get their AI that they've created patented.
Right, let alone that secondary, downstream. Right.
Yeah. So I'm like, maybe we should worry about. I don't want to begrudge anybody, because I think it's an interesting question, and it's one that I think eventually AI will have to be able to be an inventor or some sui generis protection or something like that. So I don't want to discourage people from talking about that, but I do think when you hear like the patent office or members of Congress or whoever talking about that issue, it's like, maybe dial it back. Let's get whether the actual human who has invented the AI, can they be an inventor?
Let's fix that front end problem first, right? And we're jumping, like you say, we're kind of jumping 2 steps ahead on that one.
Well, this is great. This was fascinating. I really appreciate you being here.
Thanks, Gene. I really appreciate it.